Got a question from TikTok asking if a landlord can text, I guess, this tenant bad names and swear at them for being late, and I guess this tenant asked them to go check on something that wasn't working at the property. Is that allowed? Hi, my name is Rob Wells. I'm the Landlord Warrior on TikTok and YouTube. Please feel free to like, share, and subscribe to our videos. Now, I'm going to just say this, okay? Can a landlord curse at a tenant or call them bad names? I don't know, bad name, that's relative. Here, I can call you your deadbeat, or you're late with your rent or something like that. I mean, it's free country. The question should be, should you as a landlord say anything that, call a tenant bad names or anything like that? And if you came to me as a landlord, I'd tell you absolutely not. You do not want to create a written record of, saying bad things to your tenant, okay? There's a difference between enforcing the terms of your rental agreement and taking action, such as if your tenant is being late, the state law allows you to issue 3-day notice to pay rent or quit, okay? That's allowed by law. That's a protected communication. Calling your tenant, like an SOB, you're deadbeat, you're late, you're always breaking stuff, you just, you're, a bad person, blah, blah, blah. No bueno. It's not good, okay? You know why? Because here's the thing, okay? If there's ever any type of litigation regarding the tenancy, such as, you get sued or, even in an eviction, that type of deal, text messages, anything in writing, emails, letters, so forth, that stuff could all come back and haunt you, and it could be used as a defense in an eviction case that the landlord unduly harassed the tenant. And you got to remember, landlords, there are a lot of local municipalities that have their own local ordinances that are called anti-harassment ordinances, that if you violate that ordinance, basically the landlord could be on the hook for big fines and penalties under the ordinance, including attorney's fees and costs. And you don't want to be on the wrong end of the law on something like that, okay? You don't want to be calling a bunch of SOBs, that type of deal. On paper, basically, that could be discoverable by a tenant's attorney or the tenant themselves about what you talked about. That stuff, I've seen text messages haunt landlords in litigation. It's not good. It's not a good thing, okay? So my recommendation to folks is, if you're gonna, communicate with your tenant, communicate legal notices, like a 3-day notice to pay rent, okay? If your tenant is violating the lease and they're not doing what they're supposed to be doing, communicating to your tenants, hey, you are violating the lease in such and such way. We saw you do this. We need you to stop it pursuant to paragraph blah, blah, blah. See, that you're enforcing your rights. That's different than calling someone a bad name or, getting upset, okay? When you're at the point of getting upset, I'd probably take a breath and kind of just let it be instead of sending that frustration over, because that's not going to do you any good. Being upset with your tenant is not going to be any good with you at addressing what the problems are. If they're not paying their rent or doing something, not doing what they're supposed to be doing under the lease, okay? And if you need help dealing with something like that, it's best to contact legal counsel to tell you what your rights are and so forth, if you don't know what your rights are. Okay, so landlords, if you have a problematic tenant situation, they're not paying the rent or violating the lease, and you're in the Northern California area, feel free to reach out. We might be able to help out. Put your comments, questions down below. Until next time, folks, I'll talk to you then. Thanks.